We have a smashing victory in favor of the Second Amendment. However, it is by no means complete. We're talking about Harrel versus Raoul. We're talking about the Firearms Policy Coalition, as well as the Second Amendment Foundation, kicking Illinois up and down the state. But wait, we of course have details for you. Since I didn't release this video on Friday, I want to make sure I get you all sorts of good stuff. I read the entire 168-page decision linked in the description box below. I'm going to be leading with my key takeaways, so be sure to stick around for that. And of course, at the end, our ever popular quote of the day. Guys, there's some really interesting nuances coming up ahead, so let's get into it. So first, we're going to lead with this banger of a quote, as the kids will say. Quote, "The Protect Illinois Communities Act is an unconstitutional affront to the Second Amendment and must be enjoined. So saith federal judge Stephen McGlynn." That is the judge who heard the 4-day bench trial. Bench trials means to a judge by him or herself, as opposed to a jury trial. 4-day bench trial back in September, issued his written decision, 168 pages, as I already mentioned, linked in the description box below, so you can read it yourself. All the fun in the world. It's a pretty well-written decision. There's a couple things I don't agree with. I'm going to be covering that as we get through this. But let's push through to the key takeaways. First, we continue with the quote, "The government may not deprive law-abiding citizens of their guaranteed right to self-defense as a means of offense," end quote. What is he saying here? You cannot play offense against crime by just desecrating individual rights and civil liberties. Cannot do that. Not the way this works. Yes, no right is absolute. We'll be touching on this in a bit. But first, we have to get to one of the really bad things here. The judge was realistic about the fact that he knew this decision would be appealed. After all, this was the same judge that enjoined this as part of the preliminary injunction way back, created Freedom Week until it was reversed by the 7th Circuit Court of Appeals. So being realistic this time, rather than just saying, hey, this injunction goes into effect immediately, did not do that this time. I'm not supporting that decision. I'm just explaining why he likely made that. In this way, basically, the government can, and they already have, filed their notice of intent to appeal this particular order. So realistically, this permanent injunction has no major lasting impact beyond establishing a lot of the facts, beyond giving a pretty darn good written decision and discourse. Again, a few things I disagree with and I will be going after in this video here today. So that's kind of where that stops. Let's take a look at a few key takeaways before I go a little bit more into the decision. So a couple big things up front that you probably have already implicitly picked up on. The decision strikes down the so-called assault weapons ban that banned approximately, I think it was 170 different types of firearms, including all AR15s, AK-47s, you name it. It also put restrictions on magazines. I think it was 11 rounds and up on rifles, 16 rounds and up on handguns. However, if you go to page 104 of the decision, the judge actually goes to uphold the 50 caliber ban, basically ruling in the space of a paragraph that I also have copy-pasted that paragraph in the description box below, saying that, look, 50 caliber, they're large, they're heavy, they recoil a lot. There's no legitimate self-defense usage, therefore he's upholding that ban. He was doing so well up until page 104 when I was reading this. We all know, and I'll be citing this law momentarily, there is no self-defense component to the Second Amendment. In fact, if you rewind to DC versus Heller, 2008, the first of our monumental Second Amendment cases, the anti-gunners were arguing that self-defense is a subsidiary right. It's a smaller right to self-defense. It's not the right? Remember back in the 90s and the aughts, the anti-gunners kept saying, well, AR-15s have no sporting purpose. There's no sporting purpose to everything. Therefore, they're illegal. So first, the antis invented the self-defense, not part of the Second Amendment. It's really whether or not you can hunt. That's really what the Founding Fathers were concerned about, was hunting. Just like the First Amendment's only about whether or not you can talk about sports, I guess, right? At any rate, we go on because I could be here all day talking about this and I don't want to do that to you. Takeaway number 2, the court says, quote, the court is also not convinced that weapons like the AR-15 and its relatives are, quote, dangerous and unusual, end quote. That's very important, because dangerous and unusual weapons, along with weapons that are not in common use, are weapons that may not be found to be protected by the Second Amendment. So, we've got common use, we've got dangerous and unusual. I've done videos talking about this before. I'm not going to bore you on all of the details about this once again, but basically weapons that are in common use ought to be good to go. Weapons that may not be hyper common, like America's most popular firearm, period, with likely at this point well into the tens of millions in circulation across civilian hands in the United States. If they do not reach that threshold, or if they do not reach a threshold of being in common use, then there's going to be a question that the anti-gunners are pushing, and the Supreme Court did leave this loophole open of, well, if the firearm is dangerous and unusual. Remember, what good is a firearm if it's not dangerous, right? I mean, just realistically, do you want to defend yourself against a criminal if you don't have something that isn't dangerous and they do? Probably not going to do much good. So dangerous and unusual, that conjunctive and, it has to be both dangerous and unusual. Guys, very quickly, help us out. Hit that like button and don't forget to stick around to the very end where I get to a fun Thomas Jefferson quote for our quote of the day. Now back to the video. The judges actually, as part of this decision, also copy-pasted in the description box below, so we don't have a 45-minute video. The judge actually proffered different definitions for what constitutes dangerous and unusual for purposes of this case. He also went through what constitutes a whole bunch of other interesting definitions. So I thought that was kind of interesting. He did dangerous, he did unusual, he also did common use, all copied, pasted in the description box below. I think that was pages about 65 to 75 or so in the written decision if you want to check that out. I thought that those were pretty useful. He basically said if it's chemical, if it's radioactive, if it's noxious and things like that, it's probably going to fall under either dangerous, unusual, or both. That's just kind of skipping ahead. That's in essence what he said in very low resolution. However, by this court saying that these weapons such as the AR-15 are not dangerous or unusual, again, they're now protected by the Second Amendment. My third key takeaway is this. This case is likely going to go to the Seventh Circuit Court of Appeals, where the Second Amendment will likely temporarily die, as it pretty much always has in the past. So do not expect to win in the next step. Okay, our wins in this case was probably going to come out of the trial court decision. That's the federal district court where we just had. Then we're probably going to lose in the seventh. And then the question is what will happen in the United States Supreme Court. So your next question likely is going to be, will this case be the case that determines the constitutionality of weapons like AR-15s, the constitutionality of magazines that are not pathetically small? The answer is definitely maybe. The Firearms Policy Coalition, which you should absolutely join, already has a writ of certiorari, so they're already petitioning the U.S. Supreme Court for review on another case of theirs. We're waiting to hear back on that. Currently, we're bouncing around, waiting for all the different sides and all the different parties to get their briefs in. Then it'll be distributed for conferences and so forth. So we will see where this goes. Likely, though, it's going to be either a case coming out of Illinois or it's going to be the Maryland case. One of those cases are going to be the cases that will determine the constitutionality of America's most popular firearm. Not to mention, literally hundreds and hundreds and hundreds of millions of popular magazines, like, things that hold more than a pathetically small amount. The normal amounts that these firearms are designed to hold. So why am I talking about the Seventh Circuit if we know that ultimately their stop doesn't really matter? I'm bringing up the Seventh Circuit for one important point. The Seventh Circuit previously kicked this case back to the district court when they reversed the initial preliminary injunction, basically ruling that AR-15 rifles are militaristic in nature and therefore they're not protected by the Second Amendment. That was, in essence, the central thrust of a lot of the arguments, along with the fact that they're dangerous or unusual and those two working together, coming out of the government's central arguments as part of this case. I'm going to talk about those in a moment, but first, we need to cut to Clarence Thomas. When the Seventh Circuit shot down the preliminary injunction, this case was petitioned to the United States Supreme Court. Now, the U.S. Supreme Court really does not like taking cases prior to a final ruling, which we now have. So it really has to be something crazy, something extreme, something just really obvious and out there in order for them to take it. Now, typically when the U.S. Supreme Court rejects a writ of certiorari, it's just a rejection and it is what it is. But sometimes some judges who dissented, some dissenting judges who wanted to take the case will write something. That's what we have here on this case from Justice Clarence Thomas. He wrote very much in part, if you want to see everything he wrote, I also linked that down in the description box below. He basically talked about what I'm just going to call the Justice Clarence Thomas test. Now, he's not the one that invented this, but he's the one that has put this together very cogently coming from the bench from the United States Supreme Court. There's nothing that he's spoon-feeding this to the Seventh Circuit of this is how you do it. It goes something like this. The Second Amendment's protections, quote, extends prima facie, that's on its surface, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, end quote. That's basically step one. So if it's something you can carry, if it's a bearable arm, even those not in existence back in 1791, then on its surface, the needle starts on this is protected by the Second Amendment, by the United States Constitution. Number two, the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. Now, this is the part that recognizes the historical tradition of prohibiting the carrying of dangerous and unusual weapons. That's worded a little bit oddly because it's worded in the negative. Let me flip it to the positive. The Second Amendment does protect those weapons typically possessed by law-abiding citizens for lawful purposes, such as self-defense, such as hunting. But it's for lawful purposes. That's the part that we are anchoring on. For lawful purposes, such as self-defense and these other things. But again, this is implicitly recognizing something we've covered many, many times before, which goes back to Blackstone and so forth, talking about the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Again, if you want me to make a whole video just devoted to this particular little niche area of law, let me know. It's something that I know some of you want, but I haven't gotten the sense that it's enough to kind of overwhelm my normal production schedule. So if you guys want to see a deep dive in this topic, let me know down in the comment field below. But importantly, there is no military test. There's no feature test. There's no sporting test. The antis cannot follow the law because they do not want to go where the law, history, and tradition will lead them. Justice Clarence Thomas goes on to write tellingly, quote, the Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. That's code for Justice Clarence Thomas saying, I got you, Seventh Circuit. I see you over there. I see you. I got you. We just need to get one of these cases to the United States Supreme Court, and I'm hoping, and I'm reasonably confident we will get a good outcome here. All right, so really quickly, because this video, frankly, is already way longer than I wanted to make it. I was trying to shoot for 12 minutes, and since when has that happened for me? I want to quickly summarize the government arguments. You know what the pro-Second Amendment arguments are. History, tradition, law, all that kind of good stuff. But it's interesting to me to see the evolution and the marching of the anti-gun arguments. So here's what they are here, broken up first against the weapons themselves and then separately into the magazines. First, the so-called assault weapons ban dealing with AR15s. In essence, the government is functionally saying that there's no material difference between an AR-15 and an M16 or M4. These are effectively the same weapons. Now, how do they get there? Well, they're saying that, look, they fire the same ammunition, they carry the same features, such as pistol grips, telescoping stocks, and so forth. The only real difference between them is that one is capable of automatic fire, which is a mode that they note, and there were multiple witnesses who testified at trial to basically say, look, the majority of the time, the military does not use M16s and M4s in an automatic capability setting. They're typically using them, whether it's in training or in war, in semi-automatic. The bottom line, according to the government, basically for all practical purposes, this is the same gun. For magazines, they go on to say that normal capacity magazines are designed and made for rapid fire shooting. They say that home defense and self-defense situations rarely occur, if ever, again, this is what the government is saying, not what Tom Grieve is saying, with lengthy shootouts at long ranges with extensive exchanges of gunfire. That's their quote. They go on, quote, based on empirical analysis of almost 1,000 real-life incidents of self-defense with a firearm, it is extremely rare for a person when using a firearm in self-defense to fire more than 10 rounds. End quote. They also argue that an analysis of the database of defensive gun uses compiled by the Heritage Foundation indicates that it is rare for any kind of rifle to be used in self-defense. Moreover, the government goes on to argue that AR-15s, as well as the AK-47 platform rifles and .50 caliber rifles and other so-called assault weapons, are a poor choice as self-defense due to over-penetration risks and concerns endangering people downrange of the bad guy. They also then just pontificate that these are also not frequently used in self-defense and are also poor choices for hunting, which came as a big surprise to me as someone who knows a lot of people who hunt with AR-15s, AR-10s, you name it. But hey, you know, why let truth and evidence get in the way of a good argument, right? Although, of course, it's not a good argument. So that, in a nutshell, is basically the government's push on saying, look, you know, in the 90s and the aughts, we had this imaginary sporting use test, and now we have this imaginary self-defense test. And look, whatever isn't commonly used in self-defense, no good. Doesn't matter. We're just going to ignore what the U.S. Supreme Court has said about common use and all this other kind of stuff. And we're just going to kind of invent our own permutation on it, despite the fact that, hey, we've got all these cases, including Justice Thomas, who's come out very clearly in this very case before they made these arguments at trial saying this isn't the way the law is interpreted. I don't know what to tell you. I do not know what to tell you, other than the fact that I am confident of our victory in the long term, as long as we promptly get some cases to the United States Supreme Court. This is your wake-up call. If you've not already done so, join fantastic groups like Firearms Policy Coalition, like Second Amendment Foundation, like GOA, like National Association for Gun Rights, all those groups, and there are others too, but those are fantastic groups who are on the front lines battling to protect your rights, yours and mine. If you've not already done so, don't forget to hit that like button. Now let's close with our quote of the day. This one comes from Thomas Jefferson, and it feels rather fitting, rather apropos for this video. Quote, I prefer dangerous freedom over peaceful slavery, end quote. I'll see you all in the discussion field below, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.